Welcome to Absolute Trust Talk with your host, Kirsten Howe. Absolute Trust Talk brings you tips, tools, advice, and interviews to help you build a reliable knowledge base on estate planning, business, and finance to start preparing for your future today.
Hello, and welcome back to Absolute Trust Talk. I'm Jessica Colbert. I am an associate attorney here at Absolute Trust Counsel, and I'm joined by our managing attorney, Kirsten Howe. Today, we are doing our third part in a series that we're doing on alternative procedures to probate. We're always trying to avoid the long, complicated process of probate, and there are situations when a decedent has property titled in their name alone without beneficiary designations, where we can do some alternative procedures to avoid that. We previously talked about a procedure called a small estate affidavit, which can be used to get access to personal property that a decedent had. We are now going to talk about a procedure similar to this that can be used for real property. So Kirsten, would you please let us know a little bit about that?
Sure. So just so everybody's clear, personal property is anything that's not real estate. So it could be cash, could be stock, could be a couch, whatever it is, that's all considered personal property. It could be your cat. Everything else is what we call real property. That's real estate. So this mini procedure for real estate of small value is available without having to do a full-on probate. And how you qualify for this is the real estate in question has to be worth less than $61,500. Now, that doesn't apply to very much in California, but you can imagine there are people who have vacant lots that never got developed, those kinds of things. And similar to the small estate affidavit that we talked about last time for personal property, it's not a court process. It's a declaration. It's basically an affidavit, which is a declaration under penalty of perjury, where the person who is entitled to that real estate says certain things, and they submit these facts according to the law. And Jessica's going to walk us through what some of the particular requirements for this procedure are.
Yes, so this procedure does require a little bit more than the small estate affidavit that we talked about before. For this one, you do need to wait 6 months after the date of death. For personal property, it was only 40 days. So that's a significantly longer waiting period. There also needs to be an inventory and appraisal completed by a probate referee, which means that the probate referee is saying that the appraised value of the property is less than that $61,500.
And just so for you fans at home, a probate referee is an appraiser, someone who's been approved by the probate court, and the court has a list of people who are approved to be probate referees. You don't just go out and randomly hire an appraiser. You have to use a court-approved probate referee.
Yes, good point. Thank you. If there is a will, a copy of the will also needs to be attached to this affidavit. And then all of that together is filed with the court. And once the clerk receives it, reviews it, makes sure it's complete, then they return a certified copy of the affidavit, and that needs to be recorded with the county recorder.
Okay, so it's kind of like when we're saying that the trustee has changed in terms of ownership of a piece of real estate. We record an affidavit by the new trustee that says, now I'm the trustee and I own this property. So it's very similar. It only gets up to the clerk level. Once they approve it, you record it, and now all the world knows that next in line owns this property. So that's for property. Again, just to reiterate, when the property in question is worth less than $61,500. There's a second procedure, which is similar, but a little more complicated when the property in question is worth more than $61,500. However, we are still limited to the probate limit, which is $184,500. So as you can imagine, you could have a piece of real estate that's worth $184,500, and you still qualify for this second procedure that we're going to talk about, as long as there's nothing else in the probate estate. But if you've got a bank account and you've got, an investment account and you've got jewelry or whatever you have, a car, all of those things add up to more than $184,500. We can't use this second procedure. But if you're under that limit, but still above the $61,500 limit for the real estate, you can use this next procedure that Jessica's going to describe for us.
This second procedure is called a petition determining succession to property. And it is a bit more complicated than what we just talked about because it is an actual petition. The affidavit ended with the court clerk. This petition will actually go before a judge. So you're filing a petition saying that you have this property that's worth more than $61,500, but everything in the estate is less than the probate threshold of $184,500, and that the person filing it is entitled to that property. This also requires an inventory and appraisal by the probate referee. It also requires notice to potential heirs, beneficiaries, and there is an actual hearing. And at that hearing, if everything looks right, the judge will then sign an order saying this property is going to this person or these people. And it's only the one petition, so it does end up being much quicker than a probate, but it is a court process.
Jessica, in this petition, we are only talking about the real estate. If there happens to be a bank account or some other personal property, we would be getting that through a small estate affidavit?
Yes, that's correct.
Okay. Got it. Okay. So those are a couple of, quicker, easier processes that we can go through, even if there's real estate in the decedent's estate, as long as it's of small value, which of course, it's not that common. It's not going to cover our personal residence, probably. I can't imagine anywhere in California where you can have a home to live in for $61,500. But there are a lot of clients who have undeveloped land in more remote rural areas. And this would be nice. This would be a good process for them. Okay, so hopefully you got a lot out of that. Our next episode, and we're kind of excited to talk about this, coming next year in 2025, there's going to be a change in the law with respect to probate and our personal residence. There's going to be a big change, a big carve out, and we are going to talk about it because it's kind of exciting. It's kind of interesting, and I'm looking forward to seeing how it works. So thank you, Jessica, and thank you all for watching. We hope you got a lot out of this, and we look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.
This podcast is not meant to take the place of legal advice from an attorney and does not create an attorney-client relationship. If you do have a legal question or issue, please consult with an attorney.